Hey everyone, Dustin from Newton here, and I've got Terence, our Chief Compliance Officer and General Counsel. We wanted to talk a little bit about the Ontario Securities Commission decision on Newton and our registration, some of the issues around it, a little bit about securities law, hopefully without putting you all to sleep, and then some of the implications for where Canada might be going in the future. And I wanted to start, we've got up here on screen the Ontario Securities Commission decision document regarding Newton. And one of the first thing that kind of catches my eye anyway is statute cited. So here it talks about the Securities Act of 1990. And, I'm sure everyone listening to this call or watching this call knows this, but Bitcoin was not even in a glimmer in anyone's eye in 1990. And so what is the basis on which crypto can be regulated by Securities Act from 1990?
Sure. So, Dustin, that's a question we get, I think, very, very often, generally in the form of someone who's generally interested in exactly how securities regulation applies to Bitcoin, which I think most would view as not being a security. And the long and short of it is that if you think about Bitcoin as a commodity or anything that's not a security, then I would say that securities regulation wouldn't apply. But then the second that you take that and you put contracts on it, or you allow a user to come onto a platform and buy and sell Bitcoin and then leave that on the platform, then it starts to get into the area where it looks more like a security. And so I think the regulatory position in Canada is that if you've got a crypto trading platform that's operating in Canada where users can come and buy and sell Bitcoin, and we don't immediately settle that so that we can custody it for customers who want to leave it on our platform and maybe for an indefinite period of time, then what that user has vis-a-vis Newton is really a contract for the value of the Bitcoin that's sitting in their account on the Newton platform. And so that is, in a nutshell, sort of the thinking or the logic behind how you can take something that's a commodity or not a security and apply securities laws to the regulation of platforms that allow for that type of holding or transaction. So in the same way that like gold is widely regarded as not being a security, it's a commodity. If you took that and you turned it into an ETF, or you wrote a whole bunch of contracts, whether they're derivatives or like contracts for differences on the value of gold, then you're arguably in the area where it starts to walk and talk and feel like a security. And that's where regulators come in and say, okay, well, do you fit within the securities regulatory regime? And they would say, yes, you do. And then are you compliant? And so generally, to be in the securities business or to distribute securities, in a prior life, I worked as an asset manager, and the two big requirements were you have to deliver a prospectus. There's this thing called a prospectus requirement that securities lawyers talk about. And then there's this other thing called a registration requirement, which means that the firm and the individuals involved in distributing securities, they need to be registered with the relevant securities body. I'm in Ontario, so in Ontario and for Newton, the principal regulator is the OSC. So that means that to distribute securities in Ontario, you need to deliver the prospectus, which is lots of disclosure, and it's very prescribed. And you also need to distribute through registered firms and individuals. And so most crypto trading platforms, they kind of grew organically. And so the rules also grew around that. And what ended up happening was they said, okay, well, for Canadian crypto trading platforms, if you're not going to comply with the prospectus requirement and you're not going to comply with the registration requirement, you need exemptive relief. And that is actually what the document is that we'll go into shortly, that Dustin and I are going to kind of talk through to hopefully give everyone a better understanding of what it is we're talking about when we say that we're registered as a restricted dealer, where some of the origins for the terms of our order come from. We've received lots of questions about the questionnaire, the loss limits, and there's also various other things that are in here that get less airtime, if you will, but they also come from the order. And so I think it's good that we're talking about it, because clearly people have questions about it, and they're wondering where this came from, whether it's Newton unilaterally imposing this, or whether it comes from the regulator. And I will say that it comes from the regulator in the form of our order, after lots of discussion and back and forth, and us trying to reach a happy medium. And so that discussion happened not just with the OSC and the other members of the CSA and Newton, but it also happens across the industry. So our competitors and our peers went through the same thing. So for those that are registered, if you actually look through the orders, they all kind of look very similar. And there's one distinction that I think, Dustin mentioned we should highlight, which we'll get into later, which is sort of the two models that we're seeing are very prevalent in the Canadian industry. But that's kind of kicked up a lot of questions. And so, I think everyone's of the view that for those who are interested in knowing about it, we're happy to talk about it and get people sort of at least learning where these come from, but also maybe even comfortable with some of what's going on.
And it's kind of interesting. I was just thinking back to 2018 when we started, and our first external counsel was actually Blair Wiley, who's now the chief legal officer at Wealthsimple. And at the time, we were kind of looking at the securities law and going like, well, Bitcoin was sort of viewed as being not a security, like you said, and it wasn't really clear that absent new legislation, there really was a way to sort of shoehorn that into the existing regulatory framework. And it was sort of early in 2018 when we first heard this word contract for difference, where I think they were sort of noodling on the question of how are we going to regulate this if no new legislation is getting passed, and still there's nothing being passed or even that we know of that's in the works. And I think the thing that really accelerated that discussion and prompted more serious look at this was the Quadriga debacle. Let's call it. So I think before then it wasn't clear. That kind of crystallized the interest and intent to create a regulatory framework, and then to sort of finally now, many years later, kind of becoming a sort of the standard. One of the things that we did after getting a lot of very let's call it animated responses to our announcement was I had sort of written out the 6 myths about our OSC registration. Just to kind of talk about some of the feedback we've gotten and maybe dispel some of the notions that people had. So I thought we'd go through a few of those, talk about where they actually appear or what the pertinent sections might be in this document, and use that as the basis to provide some education. This is obviously, I think this longer discussion, is something that will appeal more to the people that are interested in the details. It's posted on Reddit, the 6 myths. It's pretty short and sweet. And we'll probably do some shorter form video as well, just to get the sort of the main points. But the first one that comes up a lot, and we'll kind of jump around a bit, is we now have a risk disclosure questionnaire, and it's mandatory. That is a regulatory requirement. But people often ask us things like, oh, well, why do I have to fill it out? You're just going to report all this to Revenue Canada. It's going to affect my taxes. Can we talk a little bit about why we have this questionnaire, what it's for, and what we do or don't do with the information?
Absolutely. So before I get into that, Dustin, I wonder if now is a good time to segue into another very salient topic that we've received a number of, I'll use your word, animated emails about, which is we have lots of customers emailing asking us about something that they heard, which is that why can't you give me a higher limit than the 30,000 fiat trading limit? And I think some people have been hearing that some platforms in Canada that are registered are offering a higher limit. And so that statement is true, but it comes with the caveat, and it comes with the distinction that I think is probably relevant right now. And if you actually look at the order on the screen, you can see that like the top line in the head note, it says application for time limited relief from, and then it lists 3 things: it's the suitability requirement, a prospectus requirement, and trade reporting requirements. And so the one thing that I think maybe gets glossed over when people think about the OSC registered trading platforms is that there's actually two predominant models that we're seeing. And so I'm not going to tell you that these might be the only two that exist to the end of time, because it's been an organic process. But the first one is the one that's probably known more in the what I'll call the traditional finance world, which is called the suitability model. And basically that means that registered firms, they have to conduct a trade by trade suitability analysis for everyone that trades on their platform. And so the thinking is that when you're onboarded, you go through a very, very fulsome questionnaire. And some platforms will also—
And to be clear, that questionnaire is usually more than 4 questions when we're talking about suitability.
Yeah. So and the reason that I'm chuckling a little is because we've received a number of requests asking why we can't designate people accredited investors and give them the unlimited exemption. And so there's this 30,000 limit that we'll get into a bit later. But basically, the suitability means that if a registered firm and the registered individual working for the firm is looking at trades, they've got a whole bunch of KYC information. So marital status, people's investment objectives, what their needs are for the money. So all those get front loaded on your onboarding under a suitability analysis, because that feeds into how registered firms look at whether or not one or more trades are suitable. And that's what gets you your high limit, because theoretically, if you were an extreme high net worth individual, you've got extreme high risk appetite, you don't need the money for a long time, you don't have any dependents, like all those things, you can reach a registered individual can reach the conclusion that, okay, I can do these larger trades with you for these crypto assets because that's suitable for you. And so that isn't the same as saying that it's going to be suitable for everyone. And that is very different. That suitability model is obviously the pro is that there could theoretically be higher limits. I will tell you that in practice, that's probably not going to be the case for everyone under a true suitability review. And that the other model, which is the model that Newton is under, or that has evolved for crypto trading platforms, is called account appropriateness. So we don't do suitability under this model. Instead, what we do is we have a simpler onboarding flow, and that onboarding flow, if you think about the questions that are asked in the new 4 questions that have been surfaced, are really to determine a user's appetite and ability to assume risk. So like whether you are comfortable with risk, but also we are required to ask questions about your income level and your asset level, because that speaks to your ability. So even if you are, you're willing to YOLO on every single asset that you see, we also required to figure out, okay, well that speaks to your willingness to assume risk, but that doesn't speak to your ability to assume risk. So under this 4-question system, we assess both, and then we also assess your familiarity with crypto assets. And then we kind of take those together and come up with, okay, is it appropriate for Newton to be allowing you to trade for the platform? And that's the extent of the inquiry. So we open the account, and once your account is open, until you hit the 30K limit, if you're in a certain province and for non-specified crypto assets, then you're good. And we don't do this trade by trade suitability. We don't have to constantly update, like if your marital status changes or your personal finances change. It's less intrusive in terms of the collection of KYC. But a lot of the questions we get is, well, are we taking those 4 answers and feeding them straight to CRA or feeding them to a regulator, or are we verifying them outside with some third party? And the answer is no. Like of course, if CRA goes through the proper process and makes the demand of that information for some reason, then we're going to require, if we're required by law to provide it, we will. But we don't, as a matter of course, release that information. The information that we collect is solely to do the assessment to figure out, okay, is it appropriate for us to open your account on Newton's platform? And that is basically, in a nutshell, where that questionnaire comes from. And so people will say, oh, well, Newton, you collected all this other KYC. How come you can't use that to give me the AI status? And I will say that the AI status or eligible crypto status is under the suitability model. But the questionnaire to reach that level, I'm going to tell you, if you think 4 questions is a lot, you don't want to see the accredited investor or the eligible crypto investor information that needs to be collected and constantly updated, because it's
Not
much
just
more
that,
full.
Terence, too. Like, in addition to having a much more in-depth, survey or questionnaire that gets into things like marital status, it also means that we have to monitor every trade, keep determining on an ongoing basis whether it's suitable for that individual, and in many cases have a registered individual call them on the phone to ask them much more questions to make sure that the trade that they just did or want to do is in fact suitable. And so I think it is a much more involved process. I think it creates a lot more liability for the platform as well, because they're sort of on the hook for determining whether every trade is suitable, and that can be challenged after the fact. So you really have to have everything kind of buttoned up. And what people may not know about securities regulation in Ontario and Canada more broadly is that it's what's called principles based, meaning they'll never give you a strict rule book per se. They'll say, here are the principles. You need to go and figure out how you apply those, and then we'll tell you later if you're wrong, in a way. Kind of like you don't know until you're being scrutinized whether you're totally correct in your interpretation.
Right. And that's actually a really good point, because we've been asked a lot why we chose one route or the other. And I will say that it's a decision that actually we gave a lot of thought to. So like Dustin and Maggie and the product team and we had a number of discussions about which path we wanted to go down, because both paths have their ups and downs. Like, would we have wanted to have unlimited trading for people if it was possible that wanted it? I'd say that it's probably not incorrect to say that the team here was leaning towards yes, and they pushed me and outside regulatory counsel very hard to figure out how to make that happen. But then when we started going down the path of realizing, well, what does that translate to in terms of user experience, you kind of then might reach a different conclusion if you say, okay, well, onboarding is going to take longer. There's going to be more personnel assigned to reviewing transactions. We have to have a dealing rep assigned to reviewing suitability, right? And all of that has the impact of being much more high touch. And for a fintech company, more high touch means theoretically that it slows down the flow of onboarding, it slows down the flow of trading, it has the potential to slow down sort of every element a bit. And it probably wasn't going to be fatal, but I think from the standpoint of Newton, we were trying to build something that was easy to use, quick, very seamless, and had a nice flow to it. And I think that's why we ended up on the account appropriateness model.
Terence, there's also a question I think that's reasonable to ask, which is why were those models the only options? Where, when you see in the stock trading world is the order execution only model, where the same sort of restrictions aren't applied. Can you speak to maybe why that wasn't considered here, or maybe we can speculate on whether that might come into favor in the future?
Yeah, and so I will preface what I'm about to say as this is speculation on my part. I think that they were trying to come up with a model that they could implement given what happened with Quadriga. And so they were trying to figure out, okay, well, how do we get firms to meet a minimum standard, level the playing field, and come up with a model that firms could implement without having to go and hire a bunch of people that were already from the securities industry to do only the suitability model. Because I think the suitability model is kind of like a known, it's like a known quantity from the regulatory perspective for most. And then I think they applied this account appropriateness model to acknowledge some of the differences in the crypto space, to acknowledge that like most crypto trading platforms aren't really giving advice. They're not they're not trying to do the suitability determination. And that most users, they just really want a quick way to onboard fiat, buy and sell their crypto assets, and on a frictionless basis. And I mean, like, at a good transaction price. And so I think you're right, though. I think it's the regulatory landscape will likely evolve, and I think also the regulators have been doing their best they can to sort of learn about the crypto space and all the nuances And at the same time, the technology is evolving, right? Like all everything that's happened in the United States, in Singapore, that's all given regulators pause for thought, and they're looking at, okay, well, how do we protect investors, or maybe not only protect investors, but prevent sort of this wider systemic risk, which is really also a concern, probably more for the SEC, but also it's got to be something that Canadian regulators are thinking about as well. So
I think an important distinction here in that it's important to understand what securities regulators are actually supposed to do, what their mandate is. Their mandate is primarily investor protection, and then I might misphrase this, but stability of markets. There's a better term for that.
Yeah, they're supposed to protect the integrity of market. Like investor protection is one key facet. Lesser known is they're supposed to create an environment. I'm paraphrasing here in my own words, but they create an environment that's conducive to capital formation. But part of that is creating to foster a competitive financial market, and one where people get the right disclosures and investors aren't being taken for a ride. And I think those come together, and so they're looking at what's happened and it's still very early days, I feel like, in the crypto space in many senses, and so they're still trying to figure out what that landscape looks like, and they're also looking around it.
The distinction I think that's important is that they're not really responsible for the macro picture, which is it's not their job to figure out what is Canada's position on cryptocurrency, or what is Ontario's position on it. They're responsible primarily for making sure that investors are protected, that they're promoting capital formation, all those things. But they're not the ones that are writing the laws. And there's a big distinction between policymaking and the political side and regulating, which is generally interpreting legislation and then applying it, and being the enforcers of it. So generally, regulators are, if you look at what they're sort of incentivized to do, they don't want to appear in the news when something goes wrong and get the question, why didn't you do something to prevent this? Generally, that's a big motivator.
Absolutely. And I mean, I think that will become clear as we go through sort of some of the facets of the exemptive relief order and some of the requirements that came out of that. And so, we just talked about like suitability versus account appropriateness, why we have to surface the questionnaire. Those of you who have made it through the questionnaire will also see that there's a risk statement, which is a risk disclosure, sort of like, hey, it shouldn't be anything new, but it's basically we're required to tell you or about the risks of investing in crypto assets. That inherently financial assets can be risky.
If you know off the top of your head, can you pull up where in the document that stuff appears, just so we can maybe point out some pertinent sections?
Sure. Let me.
It's only I think 27 pages, so it's not like, I'm not going to say it's like a riveting read. It's not like Game of Thrones, but it's not too difficult of a read. But we can point out a few things that might be interesting to people.
Absolutely. So I will. So the questionnaire itself is a bit of a ways down. So it begins.
The appropriateness. Yeah. Okay. Here we go.
Yeah. So it begins here. So the Know Your Client and Account Appropriateness Assessment. So if you recall, in the head notes and above, it says we get suitability relief and registration relief, but in exchange, we agree we're going to do sort of 24 onward. So we've got 25 is really the KYC for AML purposes. So Noon is also a registered money services business. There's nothing to do with securities registration, but that's to do with the fact that we are required to act as gatekeepers to the banking system, basically the flow of fiat through and so if you start with 26, you'll see the account appropriateness factors. And this is really the origin of the 4 questions that Dustin alluded to earlier, which is we ask questions in order to assess your experience and knowledge in crypto assets, financial assets and income risk tolerance. And as part of our KYP, we also look at the crypto assets that are available on our platform. And so
and people
that's a
probably
separate
didn't
box.
realize seeing the questionnaire that like these things are very proscribed, like they're written in here. These are the things we're assessing, and that translates into directly how the questionnaire is, the questions are phrased and what we're asking and how many questions there are. So this is very much like, it's very specific what we're required to do.
Yes, and to be clear, the exemptive relief order goes back and forth between all the lawyers a number of times. It is a heavily negotiated document, and even amongst the securities regulators, so all the provincial regulators that make up the CSA, it circulates amongst them, and they tweak commas, they tweak every single word, and every single sentence in here, and they go over it with a fine-tooth comb. And so the end result is what you see here, but everything that we've quote unquote like turned on or are required to implement in the last since registration, so in the last 2 weeks or a week and a half, has come from this document. And so for anyone who's truly interested, or you don't need to take Dustin's word for it or my word for it. You can, there's a link to the OSC page with our order. You can literally dive into the order and you can see where our account appropriateness comes from, where the questionnaire comes from. So you can see that we also, like in 28, we put client limits in place. And at the same time, we are required to have this risk statement that I mentioned that gets surfaced after the questionnaire.
It's all client limits are the much ballyhooed net trading limits that we've gotten a lot of questions about. I don't know if ballyhooed is
correct.
The word, but yeah,
correct. And I'm sure we will have a couple discussion points on that, just based on the number of emails hit in my inbox, most of which are a little bit annoyed, maybe even angry, until we actually explain to people what's happening. And so I will say that most to be a bit understanding once they get the full picture, but not everyone is happy with the result. And I will say that we did fight very hard to advocate for no limit or a higher limit, and ultimately the regulator said no, and that was a decision that we ultimately had to live with in order to get our registration. But I don't think that means that's the end of our advocacy for sort of crypto rules that make sense in the framework of both crypto and against the backdrop of the securities industry and traditional finance.
Well, and just before we move on to that other subject of the sort of the net trading limits and all the nuances there, I should point out, you mentioned that they're very particular about the language. If you go and you pull up another decision from another firm, you go and, for example, look at the Wealthsimple decision, which was, I think, the first one that they published. A lot of the language would be very, very similar, and actually brings us to myth number 3 in this little write-up I did, which is no other platforms is subject to these limits. Why is Newton limiting their customers, like, et cetera, et cetera. And the fact is that there are other firms that have been operating for a little while that are registered that have the exact same limits in place, Wealthsimple being one of them. And in fact, the majority of the 9 firms that are registered use the appropriateness model, and only a small minority have chosen the suitability model. And it's sort of up to each firm to decide what makes sense for them and what kind of investment they want to make into. Do they want to do suitability or do they not? So it's really all very similar. It's just we happen to, I guess, for whatever reason, our announcement ended up kind of going more viral for one reason or another.
Yeah, I feel like ours got it picked up as if we were the first, but we definitely weren't. I like to think that we just did a really good FAQ on it and explained it, and that was easy to digest, and then people.
I mean, Vitalik did screenshot it, so
did.
I feel like it was, kudos to the team for writing up a good FAQ. But yeah, let's talk a little bit about some of the net trading limits and how those work and why those were kind of imposed.
Sure. So I'll give the Coles Notes version. So if you are in certain provinces and for certain non-specified crypto assets, and I think there are 4 that have no limits, and so the end result.
Actually, sorry, let's back up for 1 second, because I think this is an interesting point. People ask about why Bitcoin, Litecoin, Ethereum, Bitcoin Cash. In 2022, it seems kind of like a bizarre list. Like, why not USDC? Stablecoins are obvious. Like, I think it's one of the more reputable stablecoins. Like, what about layer 2? All these different things. But I think that list had been first fielded back in probably 2020. I don't have like a full history of this, but probably 2020. And just the way this stuff works is that it takes a long time for consensus to be reached and kind of everyone to be on the same page, because this is all provincial and they all need to coordinate. And it just kind of, it took a while to get together. And then once they had sort of crystallized it, it's difficult to change. I think it's probably the best explanation for that.
Yes, and I also often get asked why those four. I've asked the regulator. There's all the answers I've gotten are prefaced with, "This is my view. This is not the view of any particular regulator." But some individuals there will tell you that there really was no great reason. I think they picked like Bitcoin, ETH, and then the two forks, and then they called it a day. And then they they are, I'm told, or I've heard that they're looking at others. But as Dustin mentioned, that approval process, or trying to figure out some sort of methodology for adding others, is probably a slow process. So it's
there's no
those
criticism that we have heard yet that we have probably not already discussed internally and potentially raised in our conversations. So people that are kind of pointing out that why this, why that, this is a bit strange or a bit hard to fathom. Odds are pretty good. We've already talked about that internally.
Yeah. Yes. And so I've had an exchange with a Newton customer the other day who said I was very good at answering difficult questions, and I had to tell him that it's because of all the training I get from Newton employees who are very, very hard on the questions, who are very, very, very cynical of lawyers and regulators in general, and so they definitely run. I definitely run the gauntlet with them every time I get on a call about requirements.
We love lawyers. I don't know what you're talking about. Can you imagine? Can you imagine a world without lawyers? To quote The Simpsons. But no, that is a good point. We definitely push for the most I think just taking my CEO hat off for a second, just talking personal opinion. Hopefully, getting into too much hot water. I mean, there's some things that I think make a lot of sense about what they're trying to do, like making sure that assets are being custodied responsibly, insurance requirements, audited financial statements, financial controls. There's a lot of good stuff there that I think is designed to make sure that investors are not losing their money to bad actors, or just simply to negligence, or to operators that don't know what they're doing. I think that there's a lot of really good stuff there. I think where I think there needs to be some more thought is around some of the other restrictions that I get where they're coming from, and they're kind of based on existing precedent, but they don't necessarily apply stocks and crypto are not one-to-one the same. Derivative contracts, I can't send in general. I mean, there may be some exceptions. I can't really send a derivative contract to someone to buy a cup of coffee, right? So there isn't this whole secondary use of those existing securities that you do get out of crypto, and so I think there are real distinctions in the utility of the thing that should drive how the rules evolve. But to the credit of regulators, there's no new laws to work with, and so the sort of from a political level, there has just been in Canada very little attention paid to this, and I think that's a big misstep, and I think that's something we absolutely need to advocate for, which is better laws that clarify this stuff. Because if the laws came out tomorrow and specified very clearly how this was to be regulated, that's what regulators would work with. But they don't have that. So I want to give them the benefit of the doubt in that they're doing the best they can with what they have. I hope it's a fair statement.
I agree. I think that's a fair statement.
Anyway, so I ranted a little bit there. We were talking a bit about the limits, which I guess we kind of have gone through. People should obviously know that as a business that makes money on the bid-ask spread, we're obviously not incentivized to, restrict trading in ways that we don't have to. And so, some people have suggested like, oh, why are you guys doing this? You must be making money with these restrictions. That's absolutely not the case. And I think it's the opposite. So it's something, it's not something that we were chomping at the bit to do, but it is obviously a regulatory requirement, and that's just something that we have to do, regardless what advocacy work we might do around that.
Right. And I think that's an accurate description of exactly what's happened. And so, we had just similar discussions around Ripple, Tether. Or those. I remember those were a lot of heated internal discussions. Internally,
the word sell out, capitulate, all kinds of fun, less.
That was on
words I can't say.
Internal communication. That wasn't even the external communication. So yeah, it's like, so again, if you read the order, we are required to constantly screen for security. So if a crypto asset is a security, that means we can't even have it on our platform. And so we get into this area of things that maybe the SEC thinks are securities, or they've publicly said are. The OSC maybe has not got a public statement out. And then of course, amongst, whether they be lawyers debating or just crypto enthusiasts, people debate what is and what isn't a security. I think we typically do a pretty good job of looking at what the regulators are saying, what the actual crypto asset looks like. Is it sufficiently decentralized? What's the composition of the project itself? And we kind of assess. And so I would say, like, I know that we'll never get full agreement, but I would say that if there's one that we've delisted or had to take off our platform, there are never decisions that are made lightly. There's a lot of discussion, and that sometimes we just have to make the call and we do it. So
and people say sometimes things like oh well, I can't find where the regulators have listed this as being a security. And I think what maybe should be more clear is that unless it's registered, then of course they're never going to come out and say this is a security unless it's coming out in some kind of enforcement action. And when the SEC or some large regulator comes out, even in another country, and says we believe that this has the characteristics of a security, we have to take that really seriously, because they're not doing that trivially. They're doing that because they believe, for whatever reason, it meets the criteria that would make it more on the security side than on the commodity side. So those types of things, when you say, the court cases or the case is in progress, there's no decision yet, they're fighting it out. It's like, well, that's true, but they don't do that. They don't take that kind of action unless there's a strong motivation to do it. And we have to take that into very strong consideration. So even on assets where there might be great volume, it might be widely traded, we would love to list it. Otherwise, we have to make that determination and sometimes make choices that won't necessarily be popular with customers.
Yes, that is absolutely true. And that's actually why throughout our crypto asset statements, you'll even see, like, if you look at 38 here, the regulators require us to include an express statement that no securities regulatory authority in Canada has expressed an opinion about the crypto contracts or any crypto assets made on file, meaning they don't have an opinion, but meaning also that we are required to have an opinion, and we are required to do that analysis, and we are required to get very comfortable that nothing that we've got listed is a security on the platform. And if it is,
and one of the signals is going back and looking at, for example, previous published decisions. And if you go back and look at the Wealthsimple decision, I believe they had the concept at that point of, was it prohibited assets, or there was some term they used, which I think
prohibited asset,
which I think included Ripple and Tether, or maybe just Tether. But there was they were being very explicit with that order, and that's another thing. Even though they didn't do that with ours, it is the kind of thing we have to take into strong consideration when we see that in an actual published order.
Yes, absolutely. And it's the same, like if we see the SEC puts out a statement, we know that the OSC has seen it and giving it weight. And so we want to be on top of our game and keeping on top of these things, because I think at the end of the day, even if you don't agree with everything that is in the securities regulation or in the terms of the order, at the end of the day, we want to be very proactive in our compliance, in ensuring that we we comply with all of the investor protection things that are in the order, and all the things that make Newton a safe platform, and also that make us sort of that have us going above and beyond to make sure that we are being proactive about looking at what we've got listed and looking at how we safeguard client assets. And so, like, basically, the rest of this very long order, it gets fewer questions. But I will say that, like, there are things in here like requirements for our liquidity provider, our backup liquidity provider, how we get pricing, how we ensure we get our users the best pricing. We have got RFQ. You may have seen an announcement about recently where we, the price that you pull is held for a certain amount of time, up to 10 seconds. There's a countdown, so you know the price you're going to get. Like, all of these, like, incremental platform improvements that just kind of build on each other and surface themselves in ways that make it much more user friendly, but also less visible, perhaps a safer platform. So, like, we've got a financial institution bond for crime, which is essentially insurance. We are required to do this, so not just we, but the other Canadian crypto trading platforms as the result of regulation. When you look at what happened with sort of some of the staking blowups, you look at Voyager, you look at Celsius, the model that the Canadian trading platforms are under, where we're required to separate out customer assets from our proprietary assets, we're required to store no less than 80% of our customer assets in a third party, approved National Instrument 31103 custodian, which means they have to be an affiliate. If they're a foreign custodian, they got to be affiliate of like a registered bank or trust company. So, and they have to have certain procedures. They have to have certain security, like SOC reports and certifications. They have to have all these extra things that 3 years ago no one thought about these things, but now, as sort of some of the fallout of what's happened in the industry for players that weren't careful in the space, has become, it's had real financial impact. That is now, it's taken more center stage of what people think about when they think about, okay, well, where do I want to leave my crypto assets? Who do I entrust assets with? And those are all part of the order, which means that we have to do them, and which also means that regulators come in and said, okay, do you guys do these things? Because if not, you need to. And that's, so, like, there's a whole section on how we custody assets, and so it's a lot of boring details and numbers and reports. But I'll tell you that to get to each of these paragraphs, it involved a lot of diligence, it involved a lot of negotiating, and it involved a lot of just putting things in place to safeguard customer assets.
And we have been asked fairly frequently, why do you custody assets? Why not just go to a immediate delivery model or kind of like a non-custodial model? And the reason is that, you can, and the proof is really just in the amount of assets that customers feel comfortable leaving with us. It's significant. People want assets there so they can actually trade them, or they don't feel comfortable with the risks involved in maintaining their own wallet, and they'd rather have someone else do that for them. All kinds of reasons why people might want to custody assets with us, but the fact is there's a lot of demand. I would say the majority of users do want that service. So there's a lot of utility, you could argue, in a non-custodial model where you just buy something and it gets sent to your wallet. But this is the model that our customers wanted. And so that's why we've kind of gone through this whole process. But even though I'll admit, in the early days, you look at the long list of requirements and there's some grumbling. At the end of the day, it's made us a much stronger company. Going through the audit process, really thinking top down about our controls, making sure that the principals like me, for example, can't do things, like aren't able to do things that would be horrendously irresponsible or negligent by design. That's all good stuff. And I think that this is sort of an enforcing function for us and other companies to mature. I think it'll make us, better stewards, and I think more able to speak from authority when we're sort of advancing the cause of crypto and in Canada and abroad. So there's some things that we're not as happy about. Obviously, we'll advocate for change there, but I think there's other things that we can look at this and say these are good, and I think probably can be a bit of a standard for others.
Right. Absolutely. And sorry, one thing that you reminded me of for some reason, and Dustin, you're going to have to correct my math on this, but so just back to that 30K limit that's kicked up. As we're sitting on this call, I actually literally got 3 more messages about it. So to be clear, for a coin that's not one of the 4, and if you're in a province, let's say Ontario, so you got this 30K limit, how does it work? Because that's the question that keeps popping up. So what does that mean? So it's a annual limit based on what you buy for Canadian fiat. So if you think about it another way, if you buy on the Newton platform, it lowers your limit. So you start day 1, you got a 30,000 limit. You can spend up to 30,000 on. Dustin doesn't like these. I know you don't like this term, but on an altcoin. Okay, so not one of the 4. So you buy $10,000 of that coin. That means your limit goes to 20. And if you sold 5, and the coin doesn't go anywhere in price, you sold 5 of it, you get 5K back on your limit. Your limit is now 25. And so if you deposit crypto assets that you've got from somewhere else onto Newton's platform, or you withdraw assets, those don't affect the 30. Only on-platform purchases and sells currently impact the calculation of that 30K limit. And then the other nuance I would say is that if you were to buy an altcoin, say today, and let's say you spend the entire limit, 30K, and then tomorrow it doubles in price, and you sell it for 60, you only get back 30K of limit. You can't get like more than the 30K annual limit. And so that in a nutshell is how it works. And so, because people ask all sorts of questions like, well, what if
that's a platform limit? A platform
Yeah.
limit too. So it's enforced on the platform level. It doesn't apply across platforms. It doesn't apply to DEXs. There's no, to my knowledge anyway, there's no attempt to like surveil users across these different domains. So it really is specific to the platform.
Correct. Yeah, that's a good point. So if the math gets any more complicated than that, everyone will have to ask Dustin. But in a nutshell, that's how the 30K limit works. And I mean, the questionnaire is, I think, relatively straightforward. If you read it, I'm seeing some messages that people are perhaps not paying attention and just kind of clicking, randomly clicking through, and that might restrict your account. If you are in that position, please call our customer service team. They can unlock that for you. That's the other theme for today. But please also, I would encourage you to answer truthfully. Get through it. Like the questions are simple. It allows us to do our assessment and keep your account operating. There's nothing else nefarious going on behind that. And then everything else, I think, is disclosure and sort of things that either we or the regulators think you should be aware of when investing in crypto assets. And so, I think in totality, there's been a lot that's been kind of turned on in terms of features and requirements and disclosures. But I also think that it's one underlying driver of everything we've been doing as we moved towards registration was like, Dustin had a very strong view that like, okay, no, let's keep this as polished and as good looking a machine as we can. And I think I think we've hit that. If anyone's got questions, I would certainly encourage them to reach out to our customer service team, and we will respond as quickly as we can.
All right. And with that said, I think that's a good note to end on. Let us know what you thought of this format. It was pretty much as low effort as we could possibly muster, but we wanted to try something new and see what the response was like. If you like it, maybe we'll even risk doing it live at some point, although Terence might not like that if we can't edit it. So shaking his head. Anyway, let us know what you think, and I hope you enjoyed and didn't fall asleep halfway through this. Thanks, everyone.
Thanks, everyone.